May I seek permission, Lordship, to commence the program? Thank you, my lord. Very good evening to one and all who are present here in this pleasant weekend evening. Hardly a fortnight is left before we could wind up the calendar year 2023. It is not uncommon for every individual, institution, or organization to recall, recollect, and reminiscent what has been done for the past 11 and a half months. Yes, the Honorable High Court of Karnataka, always in forefront in transformation and in the technology, striving hard to provide citizen-centric services by way of technology, has done some e-initiatives for the last 11 and a half months. And on this occasion, in the presence of Honorable Chief Justice India, we are proud that the e-initiatives to be launched. Already, all e-initiatives are in the launching pad to be launched by Honorable Chief Justice of India. Let us begin this program with the state anthem. I request all the dignitaries to rise for state anthem.
India, My Lord Honorable Srimati Justice B.V. Nagaratna, Judge Supreme Court of India, My Lord Honorable Sri Justice Arvind Kumar, Judge Supreme Court of India, esteemed sister and brother judges present here, learned Registrar General, registrars and other officers of the Registry of High Court, esteemed members of the legal fraternity, ladies and gentlemen. Good evening, namaskara. We are highly fortunate that His Lordship Honorable the Chief Justice of India has agreed to launch the ICT initiatives through His Lordship's golden hands. His Lordship himself is a tech-savvy person who always encourages the adoption of new technologies into Indian judicial system so that the access of justice becomes easy and swift and saves the precious time of all stakeholders in the system. We are also blessed in view of gracious presence of my Lord Honorable Srimati Justice B.V. Nagaratna and also my Lord Honorable Sri Justice Arvind Kumar, Judges of Supreme Court of India. The High Court of Karnataka, which is always at the forefront in improving ICT landscape in the judicial system, has been taking several innovative steps to improve the system and process by way of technological transformation, and in this endeavor has taken several initiatives in the year 2023, and the same is ready to be put in use by the duty holders and the users. The High Court of Karnataka, with the guidance of Honorable Supreme Court of India, has taken the initiatives from time to time as a part of judicial e-infrastructure, processes and practices, including citizen-centric services, to achieve the objective of e-courts projects under the National Policy and Action Plan for implementation of information and communication technology in Indian judiciary. In the current year, many e-initiatives have been initiated by High Court of Karnataka through in-house technical manpower with the support of NIC team deployed in the High Court. As such, the initiatives slated to be officially launched by Honorable Chief Justice of India today are SWAS, website of all 30 district courts in Karnataka State Judiciary. The purpose of SWAS platform is to ensure transparency, accessibility, and seamless dissemination of information to the public. A revamped website of High Court of Karnataka, online digital case diary is an Android mobile application for litigants, advocates, and government departments. Faster, that is fast and secure transmission of electronic records Karnataka, dashboard for the Honorable Judges of High Court of Karnataka, ILR bilingual through the ILR online portal, CCTV in 6 district courts as per the direction of Honorable Supreme Court of India in case of Pradyuman Bisht versus Union of India and others. E-web portal enabled for the High Court and District Judiciary. E-summons through emails. The implementation of e-initiatives facilitates the electronic filing of cases, reducing paperwork and saving valuable time. It promotes a more organized system for case management, enabling swift access to case records and filing, thus enhancing the efficiency of our judicial process. Furthermore, e-initiatives bridge geographical barriers, enabling litigants, lawyers, and stakeholders from remote areas to participate in court proceedings without the constraints of physical presence. It is an honor to welcome my Lord Honorable Dr. Justice D.Y. Chandrachud, Chief Justice of India, to launch the e-initiatives of High Court of Karnataka. We are abundantly blessed by the gracious presence of my Lord Honorable Srimati Justice B.V. Nagaratna, Judge Supreme Court of India, and so also my Lord Supreme Court of India. Thank you all. Jai Hind, Jai Karnataka.
Thank you, my lord, for the introductory note and welcome address. I, on behalf of all the present, heartily welcome our beloved Chief Justice of Karnataka, Justice Prasanna B. Varale. As we embark on new e-initiatives, we firmly believe presence of Honorable Chief Justice of India, Justice Dr. Justice D.V. Chandrachud, would be a significant milestone for us. May I request your lordship to launch the e-initiatives by clicking the mouse.
Launching of e-ILR through ILR online portal. A. In order to make available the ILR Karnataka series in bilingual for the free access by the learned advocates, litigants, officials of government department, law students and public in general, a online platform has been developed for the public use with several user-friendly search parameters for gaining knowledge in the field. Same would accomplish the vision of Phase 3 of the e-Courts project as a part of knowledge management component.
Online digital case diary Android mobile application for litigants, advocates and government department. The in-house technical team of High Court of Karnataka developed web-based online digital case diary. Now the said database has verified credential like email, mobile number and identity of the users, which more than 10,000 advocates have been registered and more than 600 government departments also have registered, as well as a number of litigant has registered to avail the service. A. The online digital case diary mobile application has been developed in collaboration with EDCS, Electronic Delivery of Citizen Services, Wing of E-Governance, Government of Karnataka, to enable the litigants, advocates and government department to keep track on the entire life cycle of cases pending and disposed before the Hon'ble High Court of Karnataka and all trial courts in the state.
E-Certified Copies platform for District Judiciary. A. As a citizen-centric service and to make available the certified copies of the orders and judgments of District Judiciary. Online e-facility has been developed in the form of District Judiciary online services to enable the advocates and litigants to make online application for getting certified copies of the orders and judgments to get the same electronically. A. In order to transmit the orders and judgments, especially bail orders, interim orders, stay orders, etc., in the real time to the trial courts and to the police, prison and other department for compliance, a platform called FASTER Karnataka has been developed in-house by the NIC team. Same would help in minimizing the physical movement of any such communication, either through post or otherwise.
The Honorable Supreme Court in Pradyuman-Bisht case emphasized that there are untoward instances which may take place in courts and hence CCTV deployment may be useful in capturing both audio and video during the proceedings of courts. This would assist High Court of Karnataka in exercising the constitutional powers under Article 235 of Constitution of India. Shubhodaya Nanda Pratiya Kannadiyarige Namaskara. Hello and welcome to Prama India from the beautiful state of Karnataka, or shall I call it the Silicon Valley of India. Now the vision of the CCTV installation project is to implement holistic and integrated video surveillance system in all the taluka and district courts as directed by the Honorable Supreme Court of India. Ramnagar district, Mandya, Hassan, Chikbalapur district, Chamarajanagar district, and Bengaluru district court, Karnataka. This is primarily for the court halls and the locations around the court complex. Not only that, it is also to capture the court proceedings and any unfortunate incidents happening in the court complex. मेरे दोनों तरफ लगा है Prama India's 5MP intelligent bullet network camera. It gives you excellent low light performance along with 120 decibel true WDR, which is wide dynamic range. Feature that identifies vehicle and human target classification, and overall bullet cameras house a larger lenses, so higher level of details over greater distances. Not just that, it also is dust resistant as well as vandal resistant, making this an indispensable device for a place like courthouse complexes. So now the place that I'm standing is the judges' entry area, and it goes without saying, since it is a judges' entry area, it requires utmost security and surveillance, and hence we have Prama India's two cameras that I installed here, one to my left, the other one to my right. These are Prama India's dome camera equipped with audio facility. This place where I'm standing is Judicial Service Center. Judicial Service Center is a place where all the court case filing is done, and to monitor the people, we have few dome cameras that are installed here from Prama India, and there is a bullet network camera to monitor the corridor. तो दोस्तों अब हम आ चुके हैं dispatch and receiving room में. जैसे कि आप देख पा रहे हो, काफी important room है, काफी सारे records रहते हैं. इसी को ध्यान में रखते हुए, to keep it safe and secure, Prama India has installed a couple of dome cameras. One is right here, one is right opposite to me. Apart from that, NVRBA, which is Network Video Recorder, in case of any electricity failure that, we have UPS as well. So camera and NVR, both of them are backed up with the help of UPS. Cam number 1, which is right here, which is Prama India's bullet network camera, which is directly focused at Honorable Judge's seat as well as the witness box here. Now this is cam number 2, which is again Prama India's bullet network camera, which is directly focused at the bench of lawyers who can either be prosecutors or the defendants. So this is cam number 3, again 5 megapixel bullet network camera from Prama India, which is again focused on the bench of lawyers, which is again prosecution or the defendant. Next camera, let me go up there and show you the next camera, which is right up here, which is again focusing on the bench of lawyers on the either side. So 2 cameras facing 2 different sides of the bench of lawyers, which means no faces or no identity is missed out in this courtroom. Okay, this is the final one. The one that is installed here, the angle at which it is installed. This is again Prama India's bullet network camera, 5 megapixels, so better clarity, higher coverage as always. Apart from that, the angle at which it is installed, it covers the entire courtroom, honorable judge, the witness box, the bench of lawyers, and everybody, and the people waiting as well. Ladies and gentlemen, the area that you see is a waiting area and the lobby area just outside the court hall. And the cameras that are installed here, they have one unique USP. They capture not just the video, but also the audio. This is Principal Judge's cabin. This is the chamber from which he can sit and observe all the happenings in and around the court complex, including the court halls, from all the angles. As you can see, this is a huge corridor. Look at the length, look at the entire area and the space available. And hence, to cover the entire area from the security and surveillance perspective, we have multiple cameras installed in the corridor to monitor all the activities. So in case of any unfortunate incident within the court complex or the court premises, we at Prama India have installed cameras at every nook and corner of Sessions and District Court. Hence, the videos from those cameras can help record and save the situation for the police team to take the access control and take the control of the situation almost immediately.
As 3WAAS website of all the 30 district courts in the Karnataka State Judiciary, the High Court of Karnataka is proud to announce the migration of S3WRs envisioned in the 4 years plan of Phase 3. However, we are able to complete the migration at the inception of the project itself, and all they are live now. A. Under Phase 3 of the eCourts project, migration of websites to new S3WAAS, secure, scalable and Sugamya website. Platform is projected, and in the said effort, the High Court of Karnataka completed the migration of all the 30 district courts websites into S3WAAS platform in compliance with GIGW. The purpose of S3WAAS platform is to ensure transparency, accessibility, and seamless dissemination of information to the public. The each district website in the homepage depicts the picture of the historical importance at the respective place.
Revamped website of the High Court of Karnataka. A. In order to improve user interface and user experience, the website of the High Court has been revamped with a new look and feel, having additional features making it accessible website. Advocate's Dashboard is an added feature as a part of online services, which contains the following services. 1. Registration of copying requests for final orders with e-payment of copying charges. 2. Registration of copying requests for interim orders, order sheet, LCR, etc. with e-payment of copying charges. 3. E-payment of court fee and process fee. 4. Registration for cause list SMS 5. E-memo for early listing of cases.
Dashboard for the Hon'ble judges of the High Court of Karnataka. As a part of revamping the website, a dashboard has been developed for the Hon'ble judges with login credentials, having beneficial features to access various services. ePay portal enabled for the High Court and District Judiciary. In order to scale up the project for paperless courts, the e-payment as one of the component of it is implemented both in the High Court and District Judiciary to enable the advocates and litigants to make online payment of court fee, process fee and copying charges, etc.
E-summons through emails. The High Court of Karnataka, as a part of CIS module by generating e-summons, started transmitting through emails by operationalizing the same in the District Judiciary, namely wherever the parties to the litigation provided the emails. The same is an additional feature, in addition to the conventional mode of service of summons through process servers, bailiffs.
Summons notices in vernacular language. The High Court of Karnataka, as a part of CIS module, started generating the summons and notices in vernacular language so as to easily access the contents of the same by the common litigants in the local language known to them. Same is a step by the High Court of Karnataka to overcome the language barrier and to make the process of the court more accessible in the language known to them.
Thank all the delegates for having watched this 11 minutes PPT presentation. Thank you. On this special occasion, we are deeply honored to have the opportunity to felicitate our esteemed guests, Honorable Chief Justice of India and guest of honor, Chief Justice B.V. Nagarjuna, Judge Supreme Court of India, and Chief Justice Arvind Kumar, Judge Supreme Court of India. Now I request Honorable Chief Justice of Karnataka, Justice P.S. Dinesh Kumar, and Justice K. Somashekar to felicitate Honorable Chief Justice of India, Dr. B.V. Chandrachud. I request His Lordship to receive our felicitation, please. Now I request Honorable Srimati Justice K.S. Mutula Madam to join with Honorable Chief Justice and Justice B. Dinesh Kumar. Honor to felicitate Srimati Justice B.V. Nagarjuna and Judge Supreme Court. Please. Kumar to join along with Chief Justice and Justice Dheeraj Kumar to felicitate Justice Arvind Kumar, Judge Supreme Court. Lordships and leadership for having received the felicitation. Thank you. Moving on to the next stage, may I now request His Lordship, Honorable the Chief Justice of India, Dr. Justice G. Chandrachud, to grace us with a few words and thoughts. Yeah.
Namaste and good evening. Let me begin by saying that two members of your family are now two members of your joint family are now two members of my immediate family, namely Nagaratna and Arvind. So I'm delighted to be here. The second thing I must say is that my mother-in-law and my three sisters-in-law stay in Bangalore. I felt a de facto son-in-law of Karnataka, but now with this headgear, the garland, I have become de jure the son-in-law of Karnataka. Officially recognized under nothing else but the authority of the Karnataka High Court. Good evening and Honorable Chief Justice, Justice Prasanna Varaye, as I call him Prasanna, Justice P.S. Dinesh Kumar, the co-chairman of the Computers and Technology Committee, all the other members of the ICT Committee, brothers Shyam Prasad, Suraj is there, Nagaprasanna, sister Hemalakha, and brother Shivshankar Goda, all the sister and brother judges present here, members of the registry. I am delighted to witness and inaugurate all these amazing initiatives which have been adopted by the Karnataka High Court. The initiatives which have been adopted by the Karnataka High Court send a clear message that in the very heart of the hub of India's technological prowess, namely Silicon Valley in Bangalore, the Karnataka High Court is not left far behind. The IT boom found its way to the rest of the country through Bangalore, and today Karnataka High Court is leading the rest of the country. Nothing succeeds like success, and there is this intense, just as the state governments are intensely involved in competition with each other to demonstrate the fruits of development that they are adopting in their states, there is this intense competition between the high courts which is going on. And I'm so glad that this is going on because every high court is trying to ensure that what they are doing is far ahead of the curve. And I'm sure that you will be able to establish that you are truly, truly far ahead of the curve. Now, in comparison to other countries, India faces a distinct challenge concerning citizens' substantive access to our courtrooms. Even if we are successful in bringing people closer to the courtroom with the use of technology, one major obstacle is the inability of litigants to comprehend the proceedings because of the barrier of language. While the Constitution recognizes 22 languages, it provides that English will be the language of the Supreme Court and generally of the High Courts as well. However, a vast majority of our citizens do not speak English. In fact, it has been found that in relation to access to English, there is also a class element at play, which creates a sharp divide between the rich, the urban elite, and the remaining population. To resolve this dichotomy and ensure that ordinary citizens can access our constitutional courts, it is imperative that we use technology for the translation of legal documents as such to our own languages and medium of discourse. I remember when I was the Chief Justice of the Allahabad High Court, I had several colleagues who wrote every order only in Hindi. And I was pretty surprised because in Marathi, of course, we use the bilingual, in Maharashtra, we use the bilingual mode. So I asked my two colleagues, I said, क्या आप सारा हिंदी में ही लिखते हैं? Do you write everything in Hindi? And my colleague said that the reason is that when we spent our life as service judges, we didn't have a single English stenographer. So right from the time that we grew into the judiciary as junior civil judges, senior civil judges, additional district judges, and then district judges, we never used English. We are only conversant with Hindi. So when we have now come to the High Court, that's the only language which we know. Now that is reflective of what is happening across India. And I think it is important that we bridge this gap. In the Supreme Court, after I took over last year, we began adopting information technology for translating all the 36,000 judgments of the Supreme Court into every language which is recognized by the Constitution. For some reason, Hindi has been a little ahead of the curve, but almost all other languages are catching up. We have translated about 30,000 judgments into Hindi. They are being verified across the states. We have constituted committees of district judges. And about 20,000 judgments have now been verified, have been uploaded in the eSCR platform. So that covers probably about the 8 or 9 or more Hindi belt states. But this same movement is occurring across India, whether it's Karnataka, whether it's in Kerala, it's in Maharashtra, in Gujarat, in Orissa. Because my mission is to ensure that all these judgments of the Supreme Court are translated into every Indian language. So that these judgments for whom the Supreme Court really exists are made known to people across India. That has similarly been our initiative in live streaming of cases, because the effort is to take the work of the Supreme Court to the homes and hearts of people. Across India, I have been hearing, in fact, I heard it in the Ceremonial lounge today, I hear it in different seminars that I attend, ordinary citizens coming up to us and saying that we are so amazed and impressed by the serious work which goes on in the Supreme Court. Small issues concerning citizens' pensions, small issues concerning whether a termination was proper, and the large issues which confront the nation, the abrogation of Article 370, whether an unstamped agreement is capable of being let in evidence at the Section 11 stage, the fact that the Supreme Court, reversed its own judgment of 5 judges within a period of 6 months, has sent a great sense of confidence in business, trade, and industry. So across stakeholders, whether it's a political establishment in matters such as Article 370, or trade and industry, when we talk about, the unstamped agreements, I'm just giving you one example. Or for that matter, marriage equality between queer couples. Should they have marriage equality? Should they not have marriage equality? Irrespective of what the outcome is, I'm not on the outcome. Outcomes are never fixed. Outcomes are bound to differ. They are capable of evolution over a period of time. The importance is that we are now demonstrating to our citizens how serious is the work which is carried on in our courts. Citizens are able to understand that the smallest to the largest problems receive extremely close attention in the court. And the dialogue which takes place in the court is a dialogue where rationality trumps over politics. And I think that represents the heart of our system. And therefore, the use of technology today is a very key mission of my endeavor as Chief Justice of India. ICT is not a stand-alone wing of the High Court anymore. When the information and communications technology revolution started in the Indian judiciary at the initial stages, we always thought that ICT is one part of the High Court. There are a few people who know information and communications technology. The rest of us are different. We do our work using the paper files. It's not just a question of making the migration from paper to digital or the electronic. That's not just enough. What we are now aspiring for is a digital transformation of the Indian judiciary. So information and communications technology has to be truly a part of the heart of our ecosystem. We cannot have this divide about some judges being conversant about technology, others not being conversant about technology. Technology is an integral part of our processes, which we have to adopt. Now, I have just for you some basic data which I have pulled out as of 14th of December 2023 in regard to the pendency of cases in the district courts in Karnataka, all available on the National Judicial Data Grid. The total pendency of cases in the district courts in Karnataka is 19,25,758. Civil cases 9,38,000. Criminal cases 9,87,000. The NJDG tells us that the oldest civil case, miscellaneous civil case 2 of 1962, was registered on 5 January 1962. The case is pending with the Principal Senior Civil Judge and CJM at Belgavi. The oldest criminal case, warrant of summons criminal cases 535/1999, registered on 28 December 1989, is pending before the Principal Civil Judge and JMFC, Neelamangala, Bangalore Rural. Many cases we find from the NJDG are pending as the accused in such cases remain absconding for years, something beyond the control of our district judiciary. In Karnataka, 1,85,390 criminal cases are pending as the accused is absconding or not appearing. We have to monitor these cases and decide what do we do about these cases, because they add unnecessarily to the burden of arrears in our courts. The oldest case, surprisingly, where the accused is absconding is 33 years old, registered on 3 June 1990, before again the JMFC at Neelamangala. Now, if you look at the drill down features of the NJDG, the total pendency of civil and criminal cases, the original pendency, the trials, constitute 81.64% of the total pendency in Karnataka. The appellate pendency is 3.90%, 75,000 cases. Applications, 1,06,720, 5.54%. Execution, 8.92%. Age-wise pendency of civil and criminal cases, 49.54% of the cases are between 0 to 1 year old. 20.83% cases are 1 to 3 years old. That is, from 0 to 3 years, our total pendency in Karnataka is about 69%. So 69% of the cases are just between 0 to 3 years old. 3 to 5 years, 14.90%. 5 to 10 years, 12.25%. 10 to 20 years old, 2.39 cases, 2.39%. About 46,000 cases are between 10 and 20 years old in the district judiciary. 0.09%, 20 to 30 years old cases, 1,644 cases. And above 30 years cases, 0.01%, 136 cases. So if we just look at the National Judicial Data Grid, and this is something which we spoke about in the recently concluded Chief Justice's conference in the context of the Constitution Day celebrations in the Supreme Court just 2 weeks ago. I was trying to impress upon the chairpersons of the ICT committees and all the Chief Justices to impress upon the administrative or guardian judges, as we call them, to look at your districts, because a simple look at the NJDG data will enable us to understand where the pendencies lies. Because if we just focus on the oldest cases, we'll be able to get rid of at least cases which are more than 10 years old. 46,000 cases only above 10 years. Above 20 years, 1,600 cases. Above 30 years, 136 cases. Are some of those cases stayed because of some stay order of the High Court? We need to get those stay orders vacated or at least modified. Are some of those cases pending because of a stay granted by the Supreme Court? If they are drawn to my attention, we'll ensure that those cases are disposed of, so we'll be able to dispose them of. Amazing disposal figures in Karnataka in 2023. The total disposal in Karnataka was 1 crore, 69 lakhs, 46,085 cases. So 48 lakhs, 22,000 civil cases were disposed of, and 1 crore, 21 lakh and 23,000 criminal cases were disposed of. So this gives us a snapshot of the entirety of the disposal in the state of Karnataka. Now, what I want to really request all the sister and brother judges here is that if we just get a little more acquainted with the use of these information and communications technology tools which are being created by this amazing computer committee which you have, ably assisted by your registry and the other wings of the state, these are tools which are available to all of us. And if we use these simple tools, we'll be able to monitor what goes on in the districts under our jurisdiction. And this is not Newtonian science. Last year, I've had figures as of yesterday. The Supreme Court of India has clocked an unprecedented disposal of cases in the last 1 year, we disposed of 52,000 cases in the Supreme Court in 1 year. And these are not cases which were disposed of as just being defective. So, 10,000 cases which are defective and you sell, where you said you pass conditional orders and they are disposed of. These are core disposals of 52,000 cases, just by simple monitoring of the litigation. So each of us, if we sit down and really monitor the litigation, this will take us a great deal forward. And I look forward to each of you who are members of this very highly tech-savvy Karnataka High Court to take the mission forward. Now, I'm really impressed with the initiatives which have been adopted. The e-ILR, bilingual, through the ILR online portal, it is so critical. The ILRs have all died down across the country. When we were young lawyers, we would look at the ILRs, if you remember. I shouldn't say if you remember, because I'm much older than most of you, that we looked at the ILR old series to find out the classical judgments. But ILR is very important because it's a free resource which we provide. The Supreme Court has provided the e-SCR, which is a free resource now. And I encourage all of you, when you cite judgments of the Supreme Court, please cite now the SCR, the e-SCR, because the e-SCR also has neutral citations. And this is a free resource available. Encourage lawyers also to cite the e-SCR as opposed to any private publications in the Karnataka High Court. The ILR bilingual is very important because just as in the e-SCR, we have now already started uploading cases from the Hindi e-SCR. And the Hindi e-SCR has a free text search portal. So just as you can search anything, you can search how many judgments have been delivered by Justice Arvind Kumar on, say, or Justice Nagaratna's latest judgment on section 115 of the CPC, which was delivered 2 days back. So you can do all that search in the English edition of the e-SCR, but you can do it in the Hindi e-SCR also. And as we go along to different languages, including Kannada, Marathi, Gujarati, Oriya, Manipuri, all across, all languages, this facility will be available for the entire country. And I think this ILR movement, which I hope gains ground in the Karnataka High Court, will also enable other high courts to receive mentorship from the Karnataka High Court. Likewise, the delivery of e-summons, an extremely important initiative of the Karnataka High Court. The use of technology by courts has allowed us to reimagine the principle of access to justice. There was a reference to the judgment of the Supreme Court in Sarvesh Mathur, where we issued several directions to ensure the continued use of video conferencing facilities across high courts. Certain high courts have adopted their video conferencing rules. They have imposed conditions on the use of video conferencing. I know that there was recently a problem, a glitch in the Karnataka High Court because of the hacking into your data. We were all perturbed by it, but this is something which we have to live by. We can't therefore stop use of technology. We have to make our systems more robust, ensure that if there's a glitch, we attend to that glitch. One thing which I must share with you is that part of the e-courts project, we are now migrating from a physical in-premises server model to a cloud-based model. So very soon, the entire data of the Supreme Court is going to be migrated to the NIC cloud, which is called Meghraj, as a result of which we will be able to have disaster recovery also based on the basis of a cloud. So that I was initially planning to have a disaster recovery center in, say, Bangalore or Hyderabad or Bhopal in a non-seismic zone. But now cloud technology has obviated that. We don't have to get land from the state governments, invest capital investments in constructing a building, putting in resource and human resources and infrastructure. All that we have is multiple clouds where we can store our data on servers within the country. So I'm sure that, as we migrate to the cloud, these problems which recently the Karnataka High Court had to encounter about, its data being hacked or its video conferencing being hacked would be substantially taken care of. You all have probably seen those little video clips doing the rounds of the video conferencing which we do in the courts, particularly on, somebody says, Patna High Court ke judge ko gussa kyun aata hai? Or this judge in Gujarat High Court got very angry with a lawyer. So now we have to live with it. Honestly, we have to live with it. Yes, absolutely. I think we have to just live with it. But also, I think we have to also reimagine our own work. We have to understand that now, by the minute, we are being observed. By the minute, we are being video recorded. By the minute, we are being audio recorded. Even if you didn't have this live streaming technology, I find in my court, in the Chief Justice Court, in the Supreme Court, people have their mobile phones on. They are constantly recording what we are writing, what we are dictating in the court. They are passing it on to these social media websites. And by the minute, we are being reported all across the country and all across the world. In fact, my sister who lives in the United States is probably far more abreast of what goes on in my court than sometimes I feel even I am. Because before the day is over, she has told me what happened in my court, because she's so keenly clued into what happens in her brother's court. So I really just want to emphasize that it's now for all of us in the judiciary to make use of these amazing tools which we have. One word about the FASTER software. I'm so glad that you are adopting the FASTER software, as we've always lived by this principle that bail is the rule and jail is the exception. But if the bail orders which we pass are not communicated to the jails, and if they are not implemented on time, then the very purpose of the bail orders gets defeated. So we developed in the Supreme Court FASTER 1.0 last year, which was a means of communicating the bail orders which were passed by the Supreme Court to the jails. The problem which we found in FASTER 1.0 was simply this: how do we ensure that those bail orders are actually complied with? Communication is all right, but how do you ensure that the superintendent of jail has actually opened his email and communicated the order to the person for whom the order is meant? So FASTER 2.0, which we have developed, uses blockchain technology, and the purpose of blockchain technology is to ensure that the authentication of the orders takes place, and that the orders which are placed on the online portal, these are orders which are not capable of being replicated, or maybe the bail orders conditions being changed. Once they are there, they are authenticated. Second, we have constituted a FASTER cell within the Supreme Court. That FASTER cell ensures that a copy of the bail order goes to the High Court, it goes to the District Court, and it goes to the jail authorities. Now, we are able to therefore monitor as to whether the bail order has been communicated, whether the bail order which was passed by the Supreme Court has been noticed by the court, which has to then impose the conditions for the grant of bail in the district judiciary, and whether compliance has been reported back to us. So FASTER 2.0, and I'm happy that this is now being used by the Karnataka High Court, because this will really help us to monitor compliance with our orders, and perhaps you will be able to take it beyond just the criminal cases into other cases on the civil side as well, where compliance has to be required by the state government. One or two last small things which I want to mention. The first is e-filing. I think we have to now ensure that we carry the bar on board, because they are very vital stakeholders, to ensure that e-filing takes place in our courts in a very large measure. We took some basic initiatives in the Supreme Court. For instance, we used to ask the lawyers to e-file, but we also used to charge them printing charges, because we had to then print those e-file copies for the benefit of judges who were not ready to look at the e-files and who wanted physical copies. So the first thing which I pointed out to my registry is this, that if you are going to ask the lawyer to pay printing charges, why on earth would that lawyer file e-file copies with you? Second, so we've waived the printing charges. Second, we told the registry that stop insisting on lawyers filing physical copies. If you have to prepare physical copies because the judges need physical copies for a small duration of time, the burden should be on us and not on the bar. The third and major problem which we have faced recently in the Supreme Court, and I dare say you will face it in the Karnataka High Court as well, is that one of our largest litigants is the state. Now, we were trying to get the states and the union territories as well as the Union of India to start e-filing. I had set down a date as 1st November 2023. It's still not been observed. I called a meeting of the Department of Justice, the Law Secretary, the Secretaries in MITI, the Ministry of Information and Communications Technology. The real problem which is faced is this. E-filing is done by a panel counsel. The panel counsel has to pay the court fee himself or herself. Their fees are received from the government after a lapse of God knows how long. I was receiving the fees of my father when he was government pleader in 1957, when I became a judge of the Bombay High Court in 2000. And every now and then, the clerk from the government pleader's department would come to me with an exercise book, a revenue stamp attached, and said, will you please sign your father's receipt of 22 rupees of fees in this land acquisition appeal in 1957. So what happens therefore is that the panel council are not willing to pay because he knows that he is not going to get a reimbursement. So we put together a meeting of all the departments, including the PFMS section of the Government of India, and we have now devised a solution by virtue of which the fee, either the court fee can be paid directly online by the department concerned, or the department concerned can merely pay the fee through any of your payment gateways which the state government has. Every state government has its own gateway, and then upload the challan about the fact that the court fee has been paid. That obviates this problem with the lawyers who represent the state. But please do take to e-filing. And the last thing which I want to emphasize before I conclude, which is the importance of training. In the Supreme Court of India, we now have a training calendar, a 365-day training calendar for the staff. And we are training everyone in the registry, from our chauffeurs up to the ICT team and our registrars. And this is not only from the perspective of information and communications technology, but the need to train everyone. We found, for instance, that there are so many women now who are coming into the court. Almost 50% of our staff consist of women. We need to also train our employees on how to deal with a woman employee. We also need to train our entire staff on how to don leadership skills. We also need to train our judges on the use of information and communications technology. So Justice Ravindra Bhatt, for instance, before his retirement, was the go-to person. It was Professor Ravindra Bhatt who would train judges who were willing to be trained on Saturdays and Sundays, answering basic questions of judges. How do I download the e-filed? How do I download a judgment from ESCR? How do I link it to the WACOM which is available with me? How do I ensure that I can access the notes which are prepared by my law clerk on my WACOM? So on and so forth. So nothing really as good as peers training peers, because we feel a little less reluctant to, confess our ignorance to our own colleagues as opposed to some domain expert from outside. Also, domain experts don't necessarily understand what our issues and problems are. So I think it's important for us to have comprehensive training programs for judges, for the entire registry. Also, it sends a sense of belonging to the institution. My take from training is that people are in a position to understand that we belong to this institution. That just as our children are growing up and our children are becoming highly educated and tech savvy, this institution is giving me something back in terms of upgrading my own skills as a member of the registry. We have recently started the Supreme Court Chronicle. I hope you've been able to access this. If you haven't, I'm going to be sending it on emails to almost all the judges of the high courts. The Supreme Court Chronicle, which we have started, showcases what the Supreme Court has done in the last month. And it's not a very legal or a formal newsletter. It gives you, in a nutshell, what activities the Supreme Court is doing. Part of what we are trying to do is to put in that chronicle, in simple one paragraph, what is it that the Supreme Court is deciding? A lot of friends who are not connected with the legal profession always tell me, why don't you judges put out in a very simple one paragraph to society what on earth you are doing to our lives? So, people don't have time to read. My judgment in the Article 370 case was only 375 pages. People don't have time to read that but you have to write it because you have to deal with the arguments, you have to summarize doctrine. You have these websites now which will tell you in literally 1 minute of reading what the latest news tells you about. We need to come on board that movement. And therefore the Supreme Court Chronicle chronicles the important judgments of the Supreme Court in the last month in one paragraph. We also have a segment for judges. When Brother Arvind Kumar traveled to the US or Sister Nagaratna traveled to Singapore and they delivered lectures, I invite my colleagues to share. Where did you go? What did you address? The community outside needs to understand the work which we do as judges. There's so much of misgiving about us judges. They think that we take holidays. They think we only work for 5 days in a week. They only think that we come to court at 10:30 and we leave court at 4 o'clock in the evening and that we go and play golf in the evening after 4 o'clock. They don't understand that the work of a judge only begins with the time which we spend in the court. What about the time in the morning, the time in the evening? You all are traveling to your districts on Saturdays and Sundays. The enormous burden of work which you carry. And the idea of doing this is not to publicize what we do, but to make an outreach to the community. For the community to understand the kind of involvement which our colleagues bring when they visit law schools, when they address moot courts, we are contributing to the evolution of our legal profession. One segment of our Supreme Court Chronicle deals with our registries. What is new in the registries? What are our registries doing? Is there something special which has been done, innovated by the registry? There's a segment on the law clerks, something on what are the law clerks doing for the institution. We had recently a blood donation camp by our registry. In fact, when one of my colleagues was seriously down with dengue, soon upon his appointment to the Supreme Court, we were short of platelets. Our staff had donated the blood so we could draw on that credit, and that's how my colleague could get the platelets required for him to be treated for dengue. So we put this all out into the platform. What are the new initiatives which we are doing? Then we begin by having a small column called Supreme Trivia, telling you in just a very brief 2 paragraphs something interesting about the history of the Supreme Court. So I'm sure that if more and more high courts start doing that, our community will be able to reach out to us. Our community will be able to understand the kind of work which we are doing. My mission over the last year is to pitchfork the work of the court, the Supreme Court and the high courts, as part of the lives of the communities. And I think that is a very important process of confidence building, that creating that sense of confidence in the community that we exist for them. And what better way to do that than using technology to take our work down to the community. I think I took much more than 10 minutes that I was allotted by Chief Justice, and he had allotted me more time, but I told him I'll speak only for 10 minutes. I didn't realize that I'll overshoot my time. I'm deeply impressed by the work which has been done by the Karnataka High Court. My very grateful compliments and thank you to the registry, to all your support staff who have been involved in this mission, to the ICT committee which is doing such excellent work to take the Karnataka High Court to a new level of the adoption of information and communications technology. So thank you very much for inviting me. It's always a pleasure to come here and share some thoughts with you.
Thank you, my lord, for inspiring and insightful speech and for complimenting the High Court of Karnataka. I express my gratitude for the same, and it gives us much to consider, to strive further to achieve more in the field. With this, it's time to sign out from the program with the vote of thanks by Honorable Chief Justice P.S. Dinesh Kumar. May I request your lordship for the vote of thanks.
Very good evening to one and all. Lord Honorable the Chief Justice of India, Dr. D.Y. Chandrachud, Honorable Justice Nagaratna, Honorable Justice Arvind Kumar, Honorable Chief Justice Prasanna D. Varale, my esteemed colleagues, the Registrar General and esteemed ladies and gentlemen. The Indian judiciary under the leadership of His Lordship Justice D.Y. Chandrachud is heading towards a technological transformation which would ultimately make judicial system as a service. Phase 3 of the e-courts project has a great vision to transform the landscape of judiciary under the leadership of his great visionary Honorable the Chief Justice. Despite his busy schedule, he was very kind enough to spare so much of time for us, and we are extremely grateful to you, my Lord. Honorable Justice Nagaratna, despite her busy schedule for the tomorrow's function, she spared her very valuable time this evening to be amongst us, and thank you very much, madam. Mr. Arvind Kumar also had several engagements. Despite that, he responded to our invite and joined us. Thank you, sir. Our Honorable Chief Justice, he has always been our guiding force, and he has mentored us, and we thank you very much for all the support. my colleagues and peers on Saturday evening for being present here, and the Registrar General and the Registry, which have worked very hard for this success of this function. I thank them deeply. Thank you, everybody.
Thank you, my lord, for proposing vote of thanks. Now we are coming to the end of the program. I am request all the dignitaries to rise for national anthem. After national anthem, there will be high tea arranged at Patron Chief Hall. All the dignitaries are requested to join at Patron Chief Hall for high tea. Let us rise for national anthem.
नायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे